To you.
Good morning.
Yeah, and I'm sure you've seen the correspondence between the. Okay, so first, it was the AGs, the deputy AG that granted an interview clarifying exactly what the status is, and there was also the Office of Special Prosecutor. What's your observations listening to the deputy AG and also reading through the statement has been issued by the OSP? Is there a cause for concern?
Okay, so a very good morning to you and your cherished listeners. First and foremost, let me establish that the Constitution mandates the Attorney General to institute actions, whether criminal or civil in nature, for and on behalf of the state. And so, at any material point in time, the client of the Attorney General is the state. So, let this be well established, and it is a constitutional imperative. Now, the same constitution under certain limited circumstances may allow or grant parliament the power to be able to pass laws that will inure to the benefit of the state as a whole. And this may also include allowing parliament to pass laws that will somehow, some way, grant a certain level of authority to some state agencies, especially the security agencies like EOCO and other related state agencies to be able to deal with criminal matters. And that's how come you find both dealing with some criminal matters. It is because it has its own act that empowers it to deal with such matters relating to money laundering and related stuff. It is also important to establish that the OSP is also an act of parliament. That office is a creature of parliament. And it is simply so because the Constitution allows for such to be done. Now, the confusion has strongly been between the creation of the office of the special prosecutor and that of the attorney general. The question to simply ask is whether the purported functions that the OSP sets out to do in terms of the mandate and the functions, the attorney general cannot equally do it. I mean, even before the law of the OSP was passed, the number of had actually gone on in respect of whether that office was a necessary creation or not. After all, is there anything that that office can do that the Attorney General office cannot undertake? Be as it may, the government of the day at the time, with its majority in parliament, decided to pass that OSP Act, and subsequently that office was established to deal specifically with corruption and corruption-related offences. Now, you note that the Constitution actually talks about the need to eradicate corruption, even though there hasn't been any explicit definition of corruption in the Constitution. But the Constitution impliedly spoke about or talked about instances where some actions will amount to what we call corruption. And so, to that extent, the Constitution still allows for the AG to deal with those matters that is considered corruption in the eyes of the law or in its estimation. And so the OSP was then created, taking advantage of the absence or the lack of explicit definition of corruption in the Constitution to then say that they were then creating that office to deal specifically with corruption. Now, the OSP Act itself says that before any corruption and corruption-related offenses are prosecuted in terms of having accused involved, it must seek the authorization of the Attorney General. So it comes back to the same place. So on that reading, it should be so easy to understand that it doesn't have its own authority to dive straight into prosecution of accused persons without first and foremost seeking authorization from the office of the Attorney General. But the question fundamentally to ask now is whether in practice they go for such authorization. And indeed, if they do not, are their actions considered legal? And so I can understand why the correspondence between the Deputy Attorney General, or if you like, the Office of the Attorney General, and the OSP seems to be bringing out some confusion, because this is clearly avoidable if indeed for each prosecution of that nature, the OSP actually did go to the office of the Attorney General to seek such authorization. It means that even when I've given you an authority to undertake a certain activity or exercise, I still have that same authority to revoke the authority that I granted you to undertake that exercise. Anybody who can appoint can equally disappoint. And so if I grant you an authority, just like a power of attorney to do something, I can equally revoke it. And so that's the semblance of the relationship between the Attorney General and the Office of the Special Prosecutor. And so it's a needless exchanges between them. The OSP indeed is supposed to be acting on the instructions of the Attorney General by the relationship that is established. Because if he doesn't authorize you to do something, I authorize you. It's an instruction. I do not authorize you. It's an instruction. Means that you cannot take any step because I haven't granted you that. And so even if I grant you the authority to prosecute, and in between the process, I observe that the way you are going, probably it might not bring out the desired outcome. Then I equally have the right to say, okay, hold the prosecution, stop it, and then I'm taking over. And that should not be a debate whatsoever, as far as the law is concerned. And so I'm a bit at loss why that matter has taken place in the first place. And then secondly, has assumed such a latitude that it is clearly in the public domain, creating needless controversy, and then parallel authority between the office of the Attorney General and that of the Special Prosecutor. No, they are not parallel authorities in any way. And so that relationship must be well established, and we must get this clear so that we don't have some of these things coming up every now and then. It's not a very pleasant situation. The law has taken its course, and the law is that as and when the AG finds that he needs a particular docket because he wants to either look at the docket and take it up himself, or he wants to look at it and still go ahead for the authority given to the OSC to proceed. The AG has the right to do that.
But I'm also sure you've read the what do you call it? The statement that was issued by the Office of Special Prosecutor, explaining that the only reason they haven't submitted the docket is because they are sort of updating it with new information. Does that lay the issue to rest, or you think there's still a matter for concern?
So, if for any reason you think that the records needed to be updated, all you need to do was to simply submit it and give that information out. That indeed, as it stands, this is what we have. That we are indeed updating the records. And so when the updated record is ready, we'll still finish with that. Simplicity. Whatever you have at any given point in time must be submitted. Any update that will come later can simply be added and then given out. As the problem been solved? As simple as that. I don't know why we try to create problems when there is none. If you ask me, as your staff, to present a report on a particular matter, and I prepared the report halfway, and you request that you need the report today, I should bring it. The rational thing for me to do is to bring what I've prepared as of today and tell you that this is where I am. And therefore, I'll plead that you give me the opportunity to go and then just wrap it up and then let you have the complete version. Is that not the ideal thing to do? But you don't keep it and be telling me that you want to update it. You don't do that because I'm telling you that I need it. Once I need it, If it is the case that you haven't started anything at all, you have no record whatsoever, that's a different thing. You cannot submit something you do not have. But once you have it, whether partly or fully, submit whatever it is that you have as of now or today. Then let me understand what the impediments are, for which reason you are unable to complete it. And if there's a need to have any update subsequently, then you let me know. It means that we are then moving at the same wavelength. But when you keep it to yourself, you are not even allowing me to have the benefit of seeing the docket in the first place. And all you tell me is that you are updating the records. I mean, that means that you are simply swelling the relationship. And indeed, you have the authority, like I said, to revoke the authority granted you to prosecute those matters. So I simply can say that because many times executions are being carried out without recourse to the agency of justice. That is why all these things. I can sense that from what is coming out now. It's so logical to draw that conclusion. Because if they did, then we wouldn't have been here. Nobody would have heard about this. All you would have heard in the news is that the AG has taken up the matter and is prosecuting it. And rightly so, because he is the one, first and foremost, mandated by the Constitution to do that. And so there may be instances of delegation where it delegates the authority. That means that you tell somebody to act on your behalf in doing something. Now, if the person is doing it on your behalf at any point in time that you think is not going the way you want it, you can equally tell the person that, oh, let me take over. I appreciate, and let me assist you. I take over and I proceed. And so that's the whole issue about it.
I see. What would you consider a resolution of this matter? Because the OSP is also denying suggestions that he might be intentionally delaying the matter. But what do you consider a resolution?
Yes. So you see exactly the point I'm even making. If you are not even being accused of being in bed with the accused person, what then prevents you from taking the docket back to the AG and wash your hands off to illustrate or demonstrate your innocence? As simple. I tell you, matters of this nature are very easy to resolve. Are you enjoying the accusation? If you are not, why don't you simply give the docket to the AG and watch how you proceed? If there are some legitimate impediments on your way, if you give it to the AG, naturally you will face those same impediments. And the world would have seen that indeed you were also determined to prosecute the matter and that there was no such relationship between you and the accused person in the first place.
So for you should give to the AG what he has.
Say it again.
So just give the docket in its current state to the Attorney General.
Yes.
Okay.
They should go ahead and give it to him.
Okay.
The Attorney General has what it takes to gather the evidence. So if you are still struggling with evidence or extradition and other related matters, he equally has the same authority.
Okay.
He can do that, state to state. As simple as that. So give it back to him. Whatever limitations he has, he himself, he will see, and then take some other measures. And in this case, you will now be a very comfortable person in your office. No accusations will be leveled against you. And then you also be observed. But when you now try to adduce reasons justifying why you don't want to give the docket to the AG, then you are simply reinforcing the perception by the general public or even by the office of the AG himself that you may be in bed with the accused person. To clear the air, why don't you just give it out free?
Sadat Haruna Alhassan, thank you very much for speaking to us.
My pleasure.
He thinks it's a simple, straightforward matter. You have docket. Give the docket as it is in its current form. To that, yes. After all, you are convinced of what was in the initial docket. That's why you issued the red notice. So it means that you're convinced that even without the new information, you were in the position to start prosecution. Yes. So give the docket in its current state to the Attorney General so that the process can continue. It's a simple, straightforward.
I agree. I agree.
Lawyer Martin Pebu is a private legal practitioner. His activism on matters of corruption, human